Give you a quick intro.
Okay. Do I need to admit somebody? Or Danny, are you doing that?
No, no, we got everything. We're doing everything. You just need to stay there and look pretty, you know.
That's hard work. Yeah.
We're just got a couple more connecting here.
Yeah. You're sort
Okay,
of
are we ready? Ready, Danny? We gotta lock the doors and turn the phones off here. Good morning, or good afternoon, everybody. We got a special presentation here by Dina Dreizler. Dina, as I mentioned at our office meeting yesterday, our Zoom meeting, Dina actually has her license here, but her specialty is trust. She's a real estate attorney. In fact, I don't know how long have you been practicing, Dina?
Since 1992. Oh, I have to do
Okay, so a few years, 30 years. So that means you must have passed the bar when you were a teenager then, right? Dina has also been active in helping TRG in our workshops. She's come to my El Camino classes and given workshops there also on trust. And she is our preferred vendor for your clients. If you have any questions on trust, she'll be glad to answer those for you. She's also been active, I just found out that she's active in the South Bay Association of Realtors, served on grievance for a few years, and she's now a member of the professional standards panel. So I encourage that of all of our agents. So Dina's going to talk about trust. So Dina, it's all yours. And please, guys, you know, we're used to doing these workshops and having feedback. So as she goes through this, either raise your hand, unmute yourself, or click on the chat at the bottom of your screen, and we'll be glad to answer any questions that you have. All right, Dina, it's yours.
Okay, thank you, Durf. Yeah, I'm Dina Dreizler, as you know, for those of you who haven't met. I can only see a few of you on my screen. I can't see everybody. So yeah, I welcome questions. If you can unmute yourself or send, I guess, Danny a question. I'm not sure if I can see it, but I'll do my best to answer your questions as long as I can hear or see them. And yeah, just Durf, to follow up with what you were saying, Durf is such a phenomenal resource to me. I don't know how many of you call him like I do. Every time I have a transaction, I call him for advice because he's so much better and smarter than me at this stuff. And when I first became an agent about 5 years ago, he said, you know, you should really get involved and you should really join the grievance committee. So I did. I think it took about a year to get on because you had to wait for a spot and take the class. So I've been on the grievance committee for, I think, about 3 or 4 years. And then just this year, I switched to the professional pro standards. Oh, there's everybody, even better, committee. And it's a great way to scare yourself because it's really a great way to learn to be on the grievance committee and the pro standards committee because you're constantly reviewing the ethics rules and the MLS rules and seeing little mistakes that people make that can snowball into problems. And so it's just a great learning tool to keep up with those kind of rules that are so important, which is not why I'm here today. I'm just, it sort of came up because Durf reminded me, and it's been a very good experience and a little way to give back to the community. But why I'm here today is I am an estate planning attorney. And so and I'm a realtor with, I'm an agent with TRG, part-time agent, full-time estate planning attorney. So I write people's estate plans, their trusts, their wills, their powers of attorney. I do trust administration, which means I help the family when someone passes away. I'm a probate attorney. So I do all these things with regards to trusts and probates and wills. And so, yeah, I occasionally get to talk to you guys about those things, trusts and wills, and how it integrates with realtors. And sometimes it comes up because you are asked to sell a house, and then when you look at the deed, maybe the owner has passed away. So there's an issue. Or maybe the house is in a trust. And so it integrates that way. I was going to sort of focus a little bit today on why people hold their property in trusts and what are the benefits of that. And I don't know if I need to kind of go a step back before I go forward and talk about what a trust is. Does anybody want me to, the ones of you I can see, does anybody want me to talk about what a trust is before I move forward with that? Okay, nobody's raising their hand that I can see, so I'll kind of assume you all know what a trust, oh, I got a thumbs up.
Paper, right?
I mean, it's basically a contract with yourself, but it has sort of three parties: trustor, trustees, beneficiaries. You can be all three of those. It's an entity, but it's a private thing. It's not recorded anywhere, and it can do certain things like owned property, and plan for what happens to your property when you pass away. There are different types of trusts. There are revocable and irrevocable. So an irrevocable trust, I wasn't going to talk about much today. They're not that common, but they are used occasionally, or when someone dies, trusts become irrevocable. Irrevocable means you can't change it anymore. Okay, you cannot revoke it. You cannot change it, and you can't get it back. If you put something in an irrevocable trust, it's not yours anymore. So that's not generally what I write for people. Usually what I'm writing for people, and most estate planning attorneys, because there's lots of them around, are writing for typical clients are revocable, which means that when you create the trust, you can change it, you can modify it, you can amend it, and you can revoke it, get rid of it. Because of all those things, the trust for tax purposes is really still you. Even though it is a separate entity and it's respected that way, it still functions on the person who's created the trust, which we call the trustor with an O, trustor, or trustors if it's a husband and wife, or two spouses, husband, wife. It functions under their social security numbers. So, gosh, this is a lot of talking just by myself. Okay, no questions so far, I don't think. I don't see any. Okay. So why do people create revocable trusts and hold their property in it? Probably the most common reason is, of course, for inheritance purposes, and to avoid probate. So probably a lot of you are familiar with probate because you may have seen properties go through probate. You may have acted as a realtor on a probate property, or you may have known a family member whose estate had to go through probate. But what happens in California when someone owns property, their name is on a deed. Sorry, I've got an airplane going ahead. I don't know if you can hear that. So, if you own property as a joint tenant, and you die, then the property automatically goes to the other joint tenant. If the second joint tenant, if there's two people on there as joint tenants and they both passed away, then we've got a issue for probate. But if you just have a property that's not a joint tenancy, it's just, let's say it's my home, it just says it's in my name, and I die, even if I have a will, there is no way for the property to be distributed to my heirs, because I've passed away. I can't sign a new grant deed that Sue over at Coach House writes for me. I'm passed away. And even if my will says, give it to my spouse, give it to my children, it doesn't just happen automatically. So what happens is a probate has to be filed in court, a probate opened, someone appointed as the executor or the administrator of the estate. And when someone is appointed by a judge to speak on behalf of the estate of the deceased person, then the property can be sold. And this also is the same case if people die with no will. A lot of people think that if you die in California and you have no will, your assets go to the state of California, but that's not true. I'm not sure why people think that, but that doesn't happen. What happens in the state of California if you don't write a will is the state of California, through the California Probate Code, which is a law, a whole set of laws, writes your will for you. And it's called intestate succession. And there's literally a list, you know, if it's, and there's two lists. There's one if it's separate property or one if it's community property. And for example, if it's community property, it all goes, and you die without a will, and the property, it goes to your spouse. If you don't have a spouse, it goes to your children. If you don't have children, it goes to your parents. If you don't have parents, it goes to your siblings. So it keeps going, okay? But the point is that whether you have a will or no will, if you die and you have property and it's in your name, a probate will need to be filed. And probates work, you know, the California court system is set up for them, but in general, clients don't like probate. I act as a probate attorney, and you know, there's lots of them around the South Bay. They don't like it because it's expensive and because it takes at least a year, and now with COVID and everything, longer, a year and a half. So that's enough about probate. I'm not going to keep going on about it, but leads me back to trust. When people create a trust, this entity, this trust, can then become the owner of the property. And literally, like when I'm writing a trust for clients, I then write deeds for their properties where I transfer the property from however they hold title, husband and wife, you know, as joint tenants, or just a person by themselves, an individual, you know, an unmarried woman, whatever it is. I take that title and I transfer it into their trust. And then they sign the deeds and I send it to the recorder's office. Now the property has moved from them as individuals and put into their trust. This entity, the trust, now owns it. Now, as the people who are the people who control the trusts are called the trustees. So the owners are called the trustors, O. The manager or the controllers of the trust are called the trustees. When you have married couple, they're usually both trustees. You have a single person, just singular trustee, one. In the trust, we always put down alternates so that when the first person who is the trustee, when they either die or even if they become incapacitated, such as dementia, Alzheimer's, we name a successor trustee in the document itself. So when we record the deed and put it in the name of the trust, the trustee now is the speaker for that entity, the manager. So if you're selling property for someone and it's in their trust, the trustees of the trust are going to be the one who sign all your documents, you know, your listing agreements and everything else. You know, Dina Dreizler, trustee. And then like, I spell it out, the whole thing of the Dreizler Living Trust dated on the documents, but it ends up abbreviating. Anyways, so now we've got the property in the trust, and then I was trying to answer the question why. So big purpose. Now the property is in the trust. If I die, my estate, that property does not have to go through probate. So number one on my list of why do people put property in their trust is to avoid probate. They're probate avoiders. You know, if you have a house or a condo or a piece of property worth, let's say, $700,000, and that's gross. It doesn't matter about whether there's a mortgage. You know, the probate can cost $15,000 to $17,000. Probates are really expensive. There's court filing fees, probate referee, bond, published in the newspaper, appraisal, all this stuff through probate. And then the biggest fee is the attorney's fee, which is a percentage. And then the executor can also get paid the same as the attorney. So probate is very costly. So one, we have the house, commercial property, whatever it is, vacant land, it's in the trust. When someone dies, no probate, okay? Whoever is the next trustee comes in and they can control that property. We file an affidavit re death of trustee. They can now sign on behalf of the trust, and they can follow what the trust says. And the trust is the map. It tells us what to do and where to go when someone dies. Which brings me to my number 2. Why do people put their properties in trusts? To plan for their inheritance, okay? So, you know, a simple trust, a straightforward trust might say, to my children in equal shares. That's a pretty plain vanilla trust. Very typical. See that a lot. Carol, are you, I don't know if are you talking to us? Are you asking a question? No.
I have a situation right now. All the siblings are co-trustees.
Nightmare.
And they cannot agree.
Yeah. So how many siblings?
4.
Mm-hmm. So, you know, when I sit with my clients, these lovely people, and they say to me, I want all my children to be co-trustees. I say, please no. Guess what happens when you have more than one person who needs to make a decision and sign off on everything? You can have conflict, and you then get stuck because somebody wants to sell or somebody doesn't, or somebody wants one realtor or wants another, or a different listing price, or yes, let's put on a new roof before we sell, or we don't. So I try, for me personally, and I've learned this over the years, to recommend to clients to just have one trustee. And I would have tried to talk that person into, oh, you have 4 children? Okay, well, we can list all 4 of them as trustees, but let's have one at a time, and then they can be alternates behind each other. But ultimately, I do have clients who say, absolutely not. I love my children all the same, even though of course they do. They all have to be trustees. And I kind of gulp and go, oh God, they'll all get along, don't worry. So sometimes the trust, Carol, will provide for the situation when there's a conflict between trustees. Oh, if there's a conflict between the 4 trustees, majority rules. Or, oh, if there's a conflict before the trustees, my daughter Sandy gets to make the ultimate choice. Sometimes, you know, an attorney will draft that in there. They will anticipate a problem. No. So if you don't have that, you're just kind of stuck, and it's not a good situation. And, you know, they may end up in court asking a judge to remove one person because they won't sign the listing agreement and everybody else wants to sell. Go ahead.
Well, where they're at, they've actually had a negotiator for the 4 of them.
Oh, a mediator or something?
Mediator for the 4 of them. And the first time it worked, the second time it got rowdy. There's a brother and sister who will not let either one of them be in charge. There's sort of an underlying thought that one will be in charge, but there's nothing clear cut about who it's going to be. So there's been tremendous arguments about all of this. And the customer I'm talking to, the sibling I'm talking to, doesn't really care. She's willing to give up. I just want to get my quarter. Just whatever you guys want to do, I'll take my 25%. And it's been going on for like a year.
Well, I can tell you, because I've been through a few of these now. These are decades old hurt feelings and problems between siblings. That's what I've learned. That's what I've learned in my conference room when this stuff happens. You know, I think, oh, I can solve this. I'm good at this. I'm a good mediator. Let's work this out. And then all of a sudden all the old heart, mom helped you with college. She was always your favorite. I resent you for this. All this stuff comes out. So it's a deep problem, and stalemates happen. And the parents are, parent who did that, they kind of knew, they sort of chickened out.
Mhm.
So unfortunately, somebody's going to have to break that stalemate. And then it also becomes like an issue of to fight over control, which is really hard to, it doesn't make sense. You end up spending thousands of dollars on attorney's fees just over control.
So Dina, you can still name, if there's 4 siblings, you can still name one in the trust that has the authority, but it still goes 25% to all 4. So the idea is that one is making the decision, and it makes everything smoother in completing the trust. And
Absolutely. So if you think of, can you guys hear that gardener? That's terrible. Hold on, I'm going to close one more window here. Okay. Yeah, so there's different players in a trust, 3 players, right? So there's the person who creates the trust, that's the trustor. Then there's the trustee who makes decisions, signs documents, and speaks for the trust. And then there's the beneficiaries. So in Carol's case, what she's saying is, mom or mom and dad, whoever it was, had 4 children, and they made all 4 children active co-trustees together and all 4 children beneficiaries. And what they should have done is made one person the trustee, and then they can have alternates. They could list all 4 of them. This is who I'll serve first, but if they're sick, this is who I'll serve. So you can list all 4, but only have it one at a time. But then the beneficiaries who receive the assets are all 4 equal. It's just not good. I don't even like to have 2 co-trustees because you can have disagreements and get stuck, which is what's happening in Carol's case. They're trying to mediate it. A year has gone by. Other siblings are, you always have the quiet siblings. You got the bully siblings. You got the problem solver siblings. You have all these personalities. And then, she's stuck. So yeah, you don't want to have my recommendation is you don't want to have multiple trustees, although occasionally my clients insist on it. Okay, so.
I got a couple more like basic questions. These have been asked of me over the months.
You want to ask a question? Are you talking? We can't hear you.
Dina, can you hear me now?
Yes.
Okay. Yeah, I've got a couple of questions that have come my way over the months. And I appreciate you telling us, I didn't know that probate is typically in that $15,000 to $20,000 range.
It's a percentage, yeah, it's a percentage of whatever the value of the estate is. It's like 4%. It goes gross, yeah, gross.
Okay, and does that include paying the executor off and paying the attorneys in? Is that?
That's only if you're paying the attorney. If the executor wants to get paid, it's going to be it's double what the attorney's fee is, because the attorney and the executor can get the same. Most of my executors waive their costs because they're a beneficiary. But like for $1 million property, the costs are going to be, more like $20,000 to $23,000. I mean, as they go up,
right.
The property goes up, it's more and more expensive.
Okay, and it's also my understanding that all the attorney fees are fixed, right, by law. It's not like you negotiate with the attorneys for your.
Right, it's a statute. So for example, it's 4% of the first 100,000, 2% of the second, 3% of the second 100,000, and then 2% between 200,000 and $1 million.
Okay.
And then it gets less after that.
And then it's my understanding that to do a simple trust, it's only maybe $2,000 or so to.
Right. Right. So different attorneys charge different amounts. An individual trust and estate plan versus a married couple. And generally, like the way I do it is it's a trust, but I also an estate plan. And most attorneys do it this way. Estate planning attorneys, you do a trust, but you also do pour-over wills and financial powers of attorney and advanced healthcare directives and HIPAAs and living wills and
So all of this is like this whole package, and that you
exactly. And it's a flat fee, and I think most attorneys do it that way, not an hourly. Say this is my fee, and somewhere in the ballpark, $1,500 to $2,500, depending. Is it an individual? Is it two people? How that kind of price.
Okay, good. And then the time involved in actually doing the trust, is it a few days or a few weeks because you have to get the documents recorded?
Yeah, for me, I'll speak for my office. I take, I usually have an initial meeting with people. We go over all their questions, what they want, the worksheet, and then I draft the documents, have another meeting where we go over them, sign them. So it's usually 3 or 4 weeks to get it all done.
And is there anyone that really does not need a trust? I mean, for example,
Yes.
if they don't have real estate, if it's just
if they don't have real estate, so if you have real estate, you pretty much need a trust, because but if you don't have real estate and if all of your assets are under $150,000 in value, you don't really need a trust. There's an exception to probate, even if you pass away and you don't have a trust, where it's probate code 13100 and 101, where it's a small estate affidavit. Maybe some of you are familiar with that. You can get the assets from a bank or financial institution without going through probate if they're under $150,000. Also, if for example, if there's an IRA and you have beneficiaries named, or there are other assets with beneficiaries named, you don't necessarily need a trust. But the thing about a trust is it does generational planning. So trusts kind of say, well, what if this, what if that? So let's say all I had was a bank account and it was $200,000. And I listed, let's say I had one child and I listed that child on my bank account. Well, what if that child passed away? There's no plan then, and now it has to go through probate. So with a trust, we do generational planning where we say, okay, I'm leaving everything to my children. What happens if, and we answer the question, well, what happens if any of my children die before me? Like I've written in my trust, I want it to go to their children if they have children. Well, if they don't have children, I want it to go to my other siblings. Well, what happens if I have no children? And then you have another paragraph in the trust. If everyone, if there's no one here, then I want it to go to these people or this charity. So you can do all this layered planning wherewith some clients will say to me, I just want to have a beneficiary named. And I said, okay, that's fine. You can do that. But you have one layer of planning. There's no what if something happens, what's the next question, which would mean then it would then force that asset back into probate if it was over $150,000.
Thank you, Dan. And then one clarification, when you started this, you mentioned that reversion to the state. Now, I was taught that if there's no heirs, right? If there's no heirs, then it goes to the state. Is that not correct?
I suppose that is possible, but what they do is they go back to deep heir hunting. And there are companies, they're actually called heir hunting companies. I filed a probate one time years ago, I don't know, 10 or 15 years ago, and I said there's no heirs. And we had I think that was sort of this handwritten will with a friend, like a deathbed will, saying he left it all to this friend, and there's no heirs. And what I learned 15 years ago or so was every probate, when you file a probate, it's public record. Like anything you file in court, anyone can look at those files. There's no privacy. And so heir hunting companies, and there's several of them, they check the probate filings every day in every court, probably. And then it's a race. And what they do is they find the heirs, and they have, generational plan. They go back generations, until you can find somebody way out, people that maybe never met. And this one, they found you know, people in other countries. I know there's like 20 heirs, distant heirs, you know, even the person,
they get a percentage then?
they get a percentage. So then they write, and by the way, the person who died told everybody, I have no relatives. I
Right.
know no, you know, she'd never met these people ever, didn't even know they existed because they were so far distant, but they are technically relatives, right?
Okay.
So then the air hunter company sends the 20 people a letter, says, hi, Durf, we're aware of an asset. You sign here and we get whatever, I don't know exactly what percentage they take, you know, 25%, 30%. We'll then hook you up with what you're entitled to. And
So you really don't see any assets that revert to the state then because of these companies?
I mean, I've never seen it. Right. It may exist. I'm sure it's existed somewhere, but I think it's extremely rare.
Well, that's good to know. Thank you. I didn't know that.
Yeah. I know people think that, but yeah, it's, all right. So we're at half an hour. Should I keep going with my list? Should I wind it down? Should I?
Yeah, go ahead.
Okay. So I'll go a little, anybody else have a question before I go on through my little list here? Okay. Connie. You're unmuting yourself.
Yeah. So my question is, you mentioned that the court will pay off attorneys and executors. Now, in which situation that executor get paid off?
Well, an executor, we're talking about probate now. An executor is entitled to get paid the exact amount as the attorney fee. It's the same percentage, that 4%, 3%, 2% when I kind of went through it. You can Google it, it's on, you know, statutory. They are entitled to get exactly the same amount. And some executors do choose to get paid the fee. It's considered income, so they're supposed to pay income tax on it, just like when I get paid through probate, I report it and pay income tax on it. So because it's income, a lot of my clients, you know, won't take it because if you just receive the money as an inheritance, there is no tax on it. But if you get paid as doing your job as an executor, you report it as income. But let's say you're one of 3 siblings and you're doing all the work and you cleaned out the house for 50 hours in the attic and nobody else raised this is, you know, did any help, then they may choose to take the executor fee and then they'll also get, after the fees and everything are paid, they'll get their 1/3. Does that answer your question? Okay.
Elva had a question too.
Yeah, who did? Elva. Hi.
Gotta unmute yourself.
Oh, can you hear me now?
Yes.
So, hi, Dina. When I've done a trust sale before, it's just a regular standard sale. The trustee hires me, we sell it. I recently did one and the attorney, my client says, we can't sell it. My attorney needs to send out a notice of sale. Why? And I didn't tell him anything because I didn't want to give him, I didn't know, but why, what's the difference between a trust or giving a notice of sale, and why wasn't my other ones not, or what's, I don't know.
Yeah, that's a great question. So in probate, if any of you have gone through a sale of real property, you know, in probate, we do a form called a notice of proposed action, which is served on all the beneficiaries to the probate, and we give them, like if I'm preparing it as the probate attorney, it lists all the pertinent terms of the sale, you know, the purchase price, the down, the realtors, the commission, as is, who's paying title, taxes, everything, just a summary. You serve it on by mail, all the beneficiaries, and they have 15 days plus 5 for mailing, 20 days to object. And so, like I have one now in probate, I talked to the realtor, I said, don't sell it. If you get a buyer, don't sell it. The escrow cannot be less than 20 days. I need to prepare the NOPA, Notice of Proposed Action, as the probate attorney. And the reason we do that, I'm going to get to your question on Elva about trusts. I'm sorry, it's a long-winded answer. I'm circling around back to you.
Okay.
So it's done in probate so that when those 15 days plus 5 for mailing run, my executor, my client is now free. Nobody can then sue her or him later and say, I don't like the terms of the sale. You should have got a higher price. I don't like that you paid, you know, whatever. You gave a credit for this. They're clean. There's no liability. So now, so that's a sale through probate with a will, right? So now, I also am a trust attorney. When people die, my client is the trustee, the successor trustee. And I advise, like what you ran into as the attorney for the trustee, to do the same thing. And it fulfills the same purpose. So I just have one same thing. She's putting the house for sale. And I said, okay, when you get a buyer, okay, so this is, my client is one of 4 siblings. They don't all get along. Somebody's mad, somebody's quiet, somebody doesn't talk. It's taken them like 9 months just to separate the personal property. Everybody's upset, you know. So I said, when you get a buyer, send me the purchase agreement and I'm going to do a NOPA for the trust. Now, the note, you called a notice of sale. My guess is it was a notice of proposed action.
Probably.
And it's the same thing, although unfortunately in trusts, it's not a 15-day period. It's 45 days, which is a little brutal because nobody wants to wait 45 days these days to be in escrow. But it's the same, it's exactly the same where I'm saying I'm going to prepare a form and say exactly what the terms of the sale are. Everything's laid out. And I'm going to mail it to those trust beneficiaries and say, if you object, it says in big writing in the bottom, if you object, just like the one in probate, if you object, sign this and send it to me. Here's my address. I want to know, you know. They can file it in court, but they don't even have to do that. Just send it back to me, the attorney, or, you know, your sibling, the trustee. We need to know if you have an objection to this.
Oh, okay. And
then when the period ends, and hopefully no one has objected, my client, and me as the attorney, and maybe even the realtor, you know, you never know who everybody's going to sue. We're all completely clean. There is no possibility that any of those beneficiaries the statute of limitations has run. They cannot later come back and say, you breached your duty, you didn't do a proper sale, you didn't tell me about it, I don't like the terms, it wasn't enough, you did this wrong, you did that wrong. It is a clean break.
Okay.
So as trust attorneys for trustees, we want to protect our clients from liability, and that's what they were doing, is my guess. And I do the same. I do the same thing because I always want to protect, you know.
Okay. Thank you, Dina.
Yeah. Okay. So we're at, what time is it? 12:37. Okay. Going back to the purposes. These are great questions. I'm glad you're asking me. And by the way, I always tell people, you know, if you do these things do come up, I don't mind if you give me a call. You know, I'll spend 10 minutes on the phone answering your question. It's just, I don't mind helping you if you have little questions. We get to know each other. It's good for everybody. Okay, so back to the trust, the purpose of the trust. It plans for the inheritance. So, you know, when I'm writing people's estate plan, they'll still think that the will, you know, people sometimes don't realize the will doesn't really have a huge purpose. Now, it's all kind of set forth in the trust. So if we're leaving it to your children, if we're leaving it to your spouse, whatever, if we're leaving it to your friends or a charity, that's set forth in the trust. Who is going to get the assets in the trust? We call it the trust estate, right? What the trust owns. If it's my trust, when I die, who's going to get it? Where's it going to go? So we're planning for that. I've avoided probate. But in addition to that, with the trust, we can have all these whistles and bells that you can't do with a will. So let's say I have minor children. I don't. My children are all grown. But, you know, we're not going to leave an inheritance to a minor child. That's not a good idea. But so a trust can create what's called subtrusts and leave assets to children until they're older. Okay. So a common thing people do is they say, well, okay, well, if I die, hold it in trust for my child. I'm going to I want you to use the assets for if they need any money for their health, for their education, for their maintenance, for their support, anything they need to live on, kind of like a child support thing, but we call it HEMS. health, education, maintenance, and support, pay for that for them, for my child. And typically somebody might say, give it to them when they're X age. Or they might say, give them a third at age 25, the next third at age 30, and all of it at age 35. That's sort of an example people do. But you can do any version of that. You can say, give it to them all when they're 25. Give it to them all when they're 50. You know, give it to them, you know, it's very flexible. In addition to just worrying about children being young, clients worry about children who have substance abuse problems. And unfortunately, when we have children who have substance abuse problems, it's not a good idea to give them an outright distribution. I mean, I've seen that several, you know, numerous times where unfortunately the money is just spent really quickly. So in that case, really good idea to keep their inheritance in a subtrust. And you can even keep it in a subtrust for someone's whole life and provide for them for their whole life, which can be really helpful. Another reason to leave it in a subtrust, if your child or your beneficiary, doesn't have to be your child, you know, it can be anybody you want to leave it to, if you're concerned about liability, if they have liabilities and there are judgments against them, they're in debt, they have creditors, leaving it in a subtrust can be a very powerful way to provide for asset protection. And, you know, people call and they want to protect their assets. You guys maybe get those questions about how do I protect my assets? It's very hard to do. Asset protection isn't that easy. But a subtrust for someone, if they are not their own trustee, if someone else is their trustee, with guidelines for HEMS, health, education, maintenance, support, it does provide asset protection for those assets against creditors of the beneficiary. Are you following that? Is that too many words? Does that make sense to you guys? Hopefully that makes sense.
Yeah, I think it does.
Okay. Durf, you with me?
Yep, it's good. I've never heard of a subtrust before.
So it's the idea, let's say Durf and your trust, or you and your wife's trust, it says, well, leave, how many sons do you have? 8, 9 sons? I forget.
Well, 3 that I know of.
Okay, 3, okay. 3, so you said, leave to my 3 sons, you know, my 3 sons in equal shares in subtrust for their lives. So let's say you had, just make it easy, you had 3 properties and you said each one gets a property. So we, you know, if you and your wife both pass, we have Danny's subtrust under, you know, the Frederick's Living Trust, and we have, I'm sorry, I don't remember your, Billy?
Yeah,
Billy's
Charlie.
Billy's subtrust under the so-and-so trust, and then there's your 3rd son is
Yeah.
Charlie. So literally when I'm funding, okay, so let's say I've got these properties in the Frederick's Trust, we put them in there years ago, and then now it's to be distributed. I create another deed going into the subtrust. And so it just goes from one trust to another. And if, like, for example, I don't want to get too technical, but let's say each of the brothers were not trustees of their own subtrust, but they each served as each other's trustees. Then if they had a lawsuit or a judgment against them, those assets are protected. If you're your own trustee, they're not protected. You don't get asset protection. But it's a pretty cool way to have asset protection if there's a judgment against you with a subtrust.
You know, one of the great things about my inheritance is I've only got about $250 between the 3 of them, so I don't think there'll be much infighting.
There you go. Just divide by 3 and pay it out.
There you go. That's right.
No problem. No problem. Well, actually, what people mostly fight about is the stuff. You know, who gets the picture, the car, the china. Okay, so I was going through my list of things.
Also, Connie has a question here also.
Where are you, Connie? There you are. Yes.
Oh yeah. So my another question is, what about the people that that I don't want to give my asset to? Okay. So how do I spell it out on my trust?
Okay. So I think you're talking about disinheriting people.
Yes.
So, you know, I sometimes have clients who disinherit some of their children.
Right.
I am not I don't judge that. It's your people's assets. They get to do with what they want. My job as the drafting attorney is to just make sure that the person is competent. You know, they're not confused, they don't have dementia, and that no one is putting undue influence on them, you know, manipulating them to change their documents or do something that's not what they want. But after I've gone through those hurdles, and I believe that this is something somebody wants, if they want to disinherit what we would consider a natural heir, which would be if you have children, your children would consider, and your spouse are natural heirs. So if you want to disinherit those, any of those natural heirs, or let's say you don't have a spouse or children or parents, maybe your siblings are your natural heirs. So whatever the first level of heirs that would be natural, if one of them needs to be disinherited, I just list it. And so in the document, I just say, you know, I disinherit my sister, you know, Sally Smith. It's just laid out there specifically. And then it's not an issue. It needs to be written down in plain black letters.
So all you have to say is I disinherit so-and-so. That's it. That will prevents the future claim after I'm done.
Yeah. I can't remember the exact sentence that it says. I said something like, I have intentionally omitted or disinherited. I have some specific sentence that I put in my trust. But yes, of course, you know, it's your asset. So you are free to do that.
Does that work for my spouse too?
Not for community property, but only for your half of the community property.
Oh, okay.
Oh,
Yeah.
oh, I see. Only my half. Okay.
Your half, if it's community property. If it's separate property, yes, because separate property you own, you know, separate property is considered property that you owned prior to marriage, or if it's during marriage, an inheritance is separate property, or a gift is separate property. But you can change that if you put it in a community account or put it in both your names. So you have to respect the character of the property, or you will change it.
I got another question here, Dina. I'm sorry for.
Questions are great.
Minutes. And you know, this is the first Zoom meeting that we've actually had feedback, so this is nice. It makes it a lot better than just a straight lecture. So some of the questions we've also had issues with is when we're getting to close a property that's a trust. Typically, we have a successor trustee, and sometimes they can't find the paperwork, or the trust has been changed a couple of times, and they don't know if they got the latest one. The attorney died, those types of issues. So you got any cure-alls for that?
No, I don't have a cure-all for that, but I've seen all those things happen too. So I tell my clients, whenever they change their trust, to keep every version of it, because someday a title officer is going to ask for that. Because they'll say, oh, it's out of date, I don't need it. I said, no, they're going to ask for all the versions of it. Don't throw it away. Keep it all together, even though you've rewritten your trust. Keep the old version. When I've been on a trust hunt, like you're talking about, you know, they rewrote their trust, but the title officer wants to see the earlier version, and they don't have it. I will try to find, you know, like you said, if you can find the attorney office that wrote it, then you can get lucky and get it that way from their archives. But you said, you know, the attorney, in your hypothetical question, the attorney died, and
yeah, we just had that. We just had that example. One of our agents, the clients were elderly, and they can't remember where they put their trust. You know, they have grown grandkids, and I'm wondering what the scenario is at that point. If I think they were able to actually find the attorney that took over their files, and it took a couple of weeks. But assuming they can't actually find that document, if the trustors are still alive, can they sign something then that satisfies the title company to transfer that property even if it's in trust? Or do they have to
I
have?
suppose it's going to depend on the title company, how flexible they're going to be and how, who it is and how many years has it been. I mean, I had one years ago, I didn't write the trust. The trustor died. The house was in the trust. They searched the entire house, couldn't find the attorney. And I filed it as a probate. We were stuck. And
Oh, wow.
so I then got a court order from the judge in probate to transfer it out of the trust and put it into the probate estate of the decedent. And then we sold it that way. We couldn't move. In fact, that's how I got that case was I think it was a cousin. She just was going through the yellow pages, calling every estate planning attorney that she could find to find out if they wrote the trust. And because she was on a trust hunt. And I said, no. And, we chit chatted. And then a month later, she called me back and she said, oh, you were so nice. I need your help. What can I do? I couldn't find somebody. And she's been a great client since then. But
well, good. And just so everybody knows that these purposely are not recorded so that the trust can be private, right? So
that's right.
If it's not in with the attorney, then you're basically stuck, huh?
Yeah. And if the trustors are still alive, if the original owners are still alive, maybe they can then work, sign something.
With the title company then, right?
I mean, they can sign a deed transferring it out of the trust, but the problem is they still don't have the trust to show the title company. Right. But if they're competent and they're still alive, it could probably, I would think the title company, the problem comes was when they passed away, you have a successor trustee and just no document,
right.
And then the title company has nothing to know. You don't even know who the successor trustee is. I can say one clue that I've, in trying to chase down the documents, sometimes when I look at the deed, the original deed when it was put into the trust, because usually it's the drafting attorney. The trust drafting attorney also drafts the deed putting into the trust. Okay. So sometimes when you look at that deed, the name of the attorney will be up in the corner, where it says deed requested by. They might have their name there. And then the other little clue is, like for me, I'm my own notary. So I, most of the time, notarize the documents. So sometimes I can figure out who the attorney is when I'm on a trust hunt by looking at the notary.
Oh yeah, and I've noticed that's a good point, because I've noticed a lot of times a notary may be an employee of
yes.
Yeah,
so I've done that kind of like Sherlock Holmes thing, trying to find the notary to figure out who I had one like on the East Coast, and we somehow got there, and figured it out.
Oh, thank you. Thanks for answering that.
Yeah, but it is. So basically keep all your versions of the trust is the lesson from that. Okay, it is, what time is it now? It's 12:52. Should I
wrap it up?
Yeah, I think I'm gonna wrap it up. Yeah. Anybody else have any questions? Okay, great. I was just gonna say the last couple of notes was spouses and divorces. Sometimes people worry about that for their children, about inheritances. So that's another reason for subtrusts, is sometimes my clients are worried about their child's spouse and getting a divorce and that kind of stuff. And there's also, this is kind of a big one, so I'm going to just throw it in. In 2016, the governor, I think it was Governor Brown then, passed SB, it's 833, part of the budget of California budget, where he changed, it was a big change for Medi-Cal laws. This is kind of huge, where when people have to go on Medi-Cal and they owned a home, Medi-Cal takes a lien on the home. So with that, when they died, Medi-Cal would then get paid back. And in 2016, they passed this amazing law as part of our budget that said, if your home is in a trust, just a plain vanilla revocable trust, nothing fancy, Medi-Cal will not take a lien on that. And then, if you die and then your surviving spouse is in there and then they die, there's no lien. So it's just this huge benefit to having your home in a trust. If you then qualify for Medi-Cal, that they won't take the money, put a lien on your home. So
Yeah,
that
'cause I
alone,
remember we used to go through all kinds of games to try to hide, to put it in somebody else's name to hide that if they had to go to the nursing home or something.
right. And then there's these fancy Medi-Cal trusts that were expensive and irrevocable and trying to avoid that.
Right.
And they just really simplified it and gave people just this huge benefit of still qualifying for Medi-Cal and not having to pay it back if the house is in a trust. So in addition, if your house is in a trust, you know, you get a full step up in basis, tax basis. Sorry, I'm just throwing this last stuff at you because it's quick. So if we do this again, we can talk about those things again if you still have questions. But thank you so much. And thank you for the questions because it's actually kind of weird to just talk and talk and talk. Much better to hear questions and be interactive.
Okay, well,
Thank you so
appreciate it,
much.
Dina. Yeah, thank you very much. And she's also available for questions. You can call her directly or
That's right.
email her. And if you look under the chat,
Oh,
you'll see her contact information. All right, Dina, thank you very much. Make it a great
Thanks.
day.
thank you. You too. Bye-bye.
Bye-bye.